Good morning, ladies and gentlemen. My name is the Vulgar Marxist. Today I will be reading to you an excerpt from Robert Hale's Coercion and Distribution in a Supposedly Non-Coercive State. This is not a LibriVox recording. This recording is in the public domain. Quotation. And while the House of Peers withholds its legislative hand, and noble statesmen do not itch to interfere in matters which they cannot understand, as bright will shine Great Britain's rays as in King George's glorious days. End quotation. From W.S. Gilbert's Iolantha. The so-called individualist would expand this philosophy to include all statesmen, whether noble or not, and to include all economic matters as among those which they cannot understand. The practical function of economic theory is merely to prove to the statesman the wisdom of leaving such matters alone, not to aid them in the process of interfering. And in foreign as well as domestic affairs, they should make no effort to control the natural working of economic events. This would seem to be the general view of Professor Thomas Nixon Carver, although he likewise speaks frequently as a nationalist. But a careful scrutiny will, it is thought, reveal a fallacy in this view, and will demonstrate that the systems advocated by the professional upholders of laissez-faire are in reality permeated with coercive restrictions on individual freedom, and with restrictions, moreover, out of conformity with any formula of equal opportunity or of preserving the equal rights of others. Some sort of coercive restriction of individuals, it is believed, is absolutely unavoidable and cannot be made to conform to any sectarian formula. Since coercive restrictions are bound to affect the distribution of income and the direction of economic activities, and are bound to affect the economic interests of persons living in foreign parts, statesmen cannot avoid interfering with economic matters due to domestic and foreign affairs. There is accordingly a need for the development of economic and legal theory to guide them in the process. What is the government doing when it protects a private property right? Passively, it is abstaining from interfering with the owner when he deals with a thing owned. Actively, it is forcing the non-owner to desist from handling it, unless the owner consents. Yet Mr. Carver would have it that the government is merely preventing the non-owner from using force against the owner. This explanation is obviously at variance with the facts, for the non-owner is forbidden to handle the owner's property even where his handling of it involves no violence or force whatever. Any lawyer could have told him that the right of property is much more extensive than the mere right to protection against forcible disposition. In protecting property, the government is doing something quite apart from merely keeping the peace. It is exerting coercion wherever it is necessary to protect each owner, not merely from violence, but also from peaceable infringement of his sole right to enjoy the thing owned. That, however, is not the most significant aspect of present-day coercion in connection with property. The owner can remove the legal duty under which the non-owner labors with respect to the owner's property. He can remove it or keep it in force at his discretion. To keep it in force may or may not have unpleasant consequences to the non-owner, consequences which spring from the law's creation of a legal duty. To avoid these consequences, the non-owner must be willing to obey the will of the owner, provided that the obedience is not in itself more unpleasant than the consequences to be avoided. Such obedience may take the trivial form of paying 5 cents for a legal permission to eat a particular bag of peanuts, or it may take the more significant form of working for the owner at disagreeable toil for a slight wage. In either case, the conduct is motivated not by any desire to do the act in question, but by the desire to escape a more disagreeable alternative. In the peanut case, the consequences of abstaining from a particular bag of peanuts may be either going without such nutrient altogether for the time being, or to conform to the terms of some other owner. Presumably, at least one of these consequences would be as bad as the loss of the 5 cents, or the purchaser would not buy, but one of them at least would be no worse, or the owner would be unable to compel payment of more. In the case of labor, what would be the consequence of refusing to comply with the owner's terms? It would either be the absence of wages or obedience to the terms of some other employer. If the worker has no money of his own, the threat of any particular employer to withhold any particular amount of money would be effective in securing the worker's obedience for a portion of the difficulty with which other employers can be induced to furnish a job. If the non-owner works for anyone, it is for the purpose of warding off the threat of at least one owner of money to withhold the money from him with the help of the law. Suppose now the worker were to refuse to yield to the coercion of any employer, but were to choose instead to remain under the legal duty to abstain from the use of any of the money which anyone owns. He must eat. While there is no law against eating in the abstract, there is a law which forbids him to eat any of the food which actually exists in the community. The law is the law of property. It can be lifted by any specific food at the discretion of its owners, but if the owners unanimously refuse to lift the prohibition, the non-owner will starve unless he can himself produce food. And there is every likelihood that the owners will be unanimous in refusing if he has no money. There is no law to compel them to part with their food for nothing. Unless then the non-owner can produce his own food, the law compels him to starve if he has no wages, and compels him to go without wages unless he obeys the behest of some employer. It is the law that coerces him into wage work under the penalty of starvation, unless he can produce food. Can he? Here again, there is no law to prevent the production of food in the abstract. But in every settled country where there is law which forbade him to cultivate any particular piece of ground unless he happens to be the owner. This again is the law of property. And this again will not be likely to be lifted unless he already has money. That way of escape from the law-made dilemma of starvation or obedience is closed to him. It may seem that one way to escape has been overlooked, the acquisition of money in some other way than by wage work. Can he not make money by selling goods? But here again, things cannot be produced in quantity sufficient to keep him alive except with the use of elaborate mechanical equipment. To use any such equipment would be unlawful except on the owner's terms. Those terms usually would include an implied abandonment of any claim of title to the products. In short, if he not be a property owner, the law which forbade him to produce with any of the existing equipment and the law which forbade him to eat any of the existing food will only be lifted in case he works for an employer. It is the law of property which coerces people into working for factory owners,